Life has been a little bit hectic, not on e-learning, on YouTube. Life has been a little hectic, but I actually got around to downloading the recordings today onto my laptop. So this evening, I can start uploading onto YouTube. Okay, so we are recording. We're busy with directors. We're looking at the two organ company. We've looked in detail at shareholder meetings. Speaking of which, if I can interrupt myself quickly, but I'll also share this on WhatsApp. Next Tuesday is a public holiday. Then there's a class on Thursday, and then on Friday you are writing your test. Tomorrow morning, not tomorrow morning, Saturday morning at 10 a.m., I will be offering an online test preparation class. Won't take you very long, just go through the work we've done so far briefly, some for the test, that type of thing. So I will be doing that. It's like a vision class on Saturday morning for those of you that are available and want to join. Otherwise, it's recorded as usual. You can subsequently listen to the recordings. And then the Thursday evening before the test, we will not have a class. You can then rather use that time to complete your preparation, your study for the test on Friday even. If that is in order with you, even if it's not in order with you, that is what is going to be happening. So we're looking at the orders of a company. We've looked at shareholders meetings, how meetings are conducted, how decisions are taken. Then we started looking at the other organ of a company, namely directors, the board of directors. We found out, first of all, I've actually sort of been lying to you so far, because I started off by saying a distinctive characteristic of a company is that the separation between ownership and control / management. I've been saying that the directors manage the company. Tuesday, I told you, well, actually, that isn't quite what happens. The directors don't actually physically manage the company. Company managers, employees that do that earn salaries for that. The board of directors, specifically in a public company, has got more of an oversight role. I check that the people that are managing the company are doing correctly. But the day-to-day operational decisions, it's actually an important principle of corporate governance that the board of directors should not get involved in operational matters. Operational matters are the decisions of the people that get paid, the experts that get paid to do the job. Board directors, more oversight function, checking that they are doing it properly in accordance to the Companies Act, etc., etc. So we looked then on Tuesday on who may be directors, who may not be directors. Also learned how directors are dismissed. Moving on then this evening, we will be looking at directors' duties. A thumbs up quickly if you can see my slides. Yeah. Thumbs up if you could see if I've successfully shared. Avelina, thank you.
Good evening, ma'am.
Okay,
Are we right
directors, do you
with
remember, uh, while I'm teaching, I'm looking at the window that has a show. Mr. Polis, Joseph Polis, your mic was on. Got a question? Not. Remember to feel free to interrupt me. Switch on and call out if you have a question while I'm teaching. You're welcome to interrupt or otherwise put it in the chat box. So the duties and
Miss?
liabilities of directors. What do directors do? What are duties expected of them? First of all, let's ask what are the sources of these duties? Where do these duties come from? Duties of directors can come from various sources. In certain instances, we learned on Tuesday that you get executive directors and non-executive directors. Executive directors are employees of the company. They will obviously have a contract of employment, which will set out certain duties. The company's constitution, the memorandum of association, can also, in many instances, detail certain duties of the company's directors. But now you can understand you get lots of different companies. So these duties, the duties that arise from the contract of employment or from the constitution, are wide and variable, differ from company to company. So it would be impractical to try to discuss them in the course of one lecture, all the potential duties you can get. Also depend on what exactly the role of the individual employee is. Are they tasked with finances, with the accounting, whatever? The Companies Act, also the Act imposes certain duties on directors. Those we're also not going to tonight. As we go along with our studies, we will come across certain duties of directors, and I will point these out. So what we're looking at tonight are the duties that arise from common law. And all directors, irrespective of common law, these common law duties apply to every director in every company, irrespective of the type of company, the size of the company, whether it's a public company or a private, whether it's listed or not listed. These common law duties apply to all directors at times. The first one sound familiar to you because you all passed introduction law for accountants. The first duty, and I want to almost go by saying the most important duty, is the duty of good faith. You've heard about the duty of good faith before, because partners in a partnership also have duty of good faith. And it's the same thing. The duty of good faith. Just give me a second, please. My apologies, I just had a bit of a domestic interruption. Duty of good faith, the fiduciary duty. Every who is in a fiduciary position, a person who has control over the assets of another, or holds the power to act on behalf of another person, has got a duty of good faith, fiduciary duty. So partners in a partnership, company directors, trustees, etc., etc. So not a duty which is unique to company directors. The bottom line is that a director stands in a fiduciary relation to his or her company to act in good faith and avoid a conflict between his or her own interests and those of the company. Should sound familiar. Partnerships, same thing. Now, I have already said that these duties apply to all company directors. So the question might arise that can a director contract out of these duties, the fiduciary duty, also duty of care, skill, and diligence, similar also to what we did in partnerships. Can they, when they accept to be appointed as a director, into agreement with the company to say that, look, this duty is to apply to them. They cannot be held liable if they breach this duty. Is this legally possible? No, it is absolutely not. Companies Act states expressly that any provisions in the articles or a stipulation in a contract which purports to exempt a director, officer, or auditor of a company against any liability towards the company, which would normally result from negligence, fault, breach of duty, or breach of trust, is void. So even if they've signed a contract which says they won't be held liable, that provision is not enforceable. They are liable. Story, full stop. So, the fiduciary duties of directors, as I've already said, this is the same as the fiduciary duty of others. People that write the textbook, etc., commonly divide or classify, categorize, that's the wrong, categorize, the fiduciary duties of directors into 4 categories. Don't stress so much about these categories, in the sense that the same act, the same wrongdoing by a director can often fall in more than one of these boxes. So these aren't clear-cut boxes, but you do need to know about the main categories of the fiduciary duty. Is to prevent a conflict of interest. They may not exceed the limitations of their powers. They must maintain an unfettered discretion, and they should exercise their powers for which they were concerned. So the duty to prevent a conflict of interest. We looked at this also when we were doing partnerships. They should prevent a conflict between their own interests and those of the company, the so-called no conflict rule. Then there's the profit rule. They must not make a profit from their fiduciary position. Doesn't mean they can't be remunerated. No, they do pay to attend meetings, etc., etc. That's not what we by no profit. They don't have to do it for free. But they cannot use contacts or information that they get from being a director, do their own thing and make a personal profit. Then similar to that, also related to that, called corporate opportunity. Any contract information or other opportunities that belong to the company must belong to the company, and they cannot usurp, they cannot take that for themselves. Strictly applied, all three of these rules, no conflict, no, the corporate opportunity rule. Potential liability, a director may be held to a profit and loss. Let's start that again. A director is the company suffers damage or suffers a loss or damage by as a result of a director breaching their duty of good faith. The director can be held liable. But other than that, even if the company itself doesn't lose any money, but the director made a profit, the director of the company may claim such profit from the director. It is interpreted by the courts as the director has to share the profit. Does not mean the director has to share or her expenses or losses. Expenses incurred in the course of making profit is for the director's own pocket, just the profit which they made at the end of the day. They can be called upon to share the company. In the study guide, if you look at the study guide, I don't have the study guide with me at the moment, but find it. In the study guide, I discuss a number of court cases that relate to direct duties, the duty to prevent a conflict of interest. Will not be assessed on those cases, but do read them. They serve as interesting examples that make it easier for you to understand the whole concept. The next category, the next class of potential breach of the duty of good faith, directors have the duty to maintain and exercise an unfettered discretion. Now, what on earth is an unfettered discretion? Unfettered, an old English word. Let's see, hands up quickly. Anybody here that has a farm and that has a horse on their farm? Mr. Pierce, you look like somebody that could ride a horse. Can you ride a horse? Nobody ride horses. Are you all city kids? Nobody with a farm with horses. And you use the example in any. If you're on your farm and you take your horse and you go for a ride on your horse, and after a while you get a bit tired, you try to stop for a while, get off your horse to make sure your horse doesn't run away. So you tie your horse to the tree. Another fancy English way of saying that is that you have fettered your horse. Tying your horse, you're fettering it. So obviously, if you unfetter it, it means untie it. Directors must exercise an unfettered discretion. They must not be tied or influenced by anybody else or another company, etc., etc. They must consider the affairs of the company in an objective manner and always make their decisions in the best interest of the company. Fairly easy to understand, not always that easy to apply in real life. Because it happens quite often that certain shareholders or groups of shareholders appoint certain persons on the board of directors, in essence, after their interest. But the moment there is potential conflict between what's best for the company and what's best for this group of shareholders or whoever that appointed them, they have to act in the best interest of the company, not in the best interest of the shareholders that appointed them. That can place them in real life sometimes in a bit of an awkward position. Best way to go about this, of course, if there's something to discuss at a board meeting and a director finds that the decision they make now, they could really be influenced by the fact that they are representing certain shareholders, the best interest for them would be to actually excuse themselves from that meeting, to step out and not participate in the decision. It goes even further. The appointment of a director by an outside party as a tool who has no idea what he or she is doing, so isn't qualified themselves to serve as a director, somebody, but that person is just a director in name, and they're actually just giving them instructions, and they don't exercise any independent thought. They must just follow instructions. This is illegal and punishable as fraud. Potential liability that can arise from the breach of this duty. The director may be held liable for fraud, and the company can set aside any decisions taken in breach of this duty. Directors must exercise powers for the purpose for which they are conferred. They must not abuse their powers. Directors have certain powers, but there is a reason behind those powers. One example for this would be that directors have the power to issue shares in the company. Now, why would the board want to issue shares? Why do companies issue shares? To raise capital. So directors have been granted this power to raise capital when and they think it's necessary. But let's say the directors are reaching the end of the term as directors, and they start realizing that, well, they're not all that popular in the company, and at the next annual general meeting, they might be replaced. And they don't be replaced, they're getting remunerated, they're getting nice sitting allowances, and this is a good thing, nice thing for them to do. So what do? They issue more shares, but not to raise capital for the company. They issue shares to their buddies, so to weight of voting, so to speak, so that at the next AGM, there are more shareholders that will vote for them to remain in office. This is a breach of their duty of good faith, a breach of their fiduciary duty. It's an abuse of power. They can be held liable for fraud, and such decisions can be set aside. Is that all three of them, or have I skipped? Okay, so sorry, let me just go back. They should prevent a conflict of interest, may not exceed the, oh, I skipped this one. Didn't actually have a slide on this one. May not exceed the limitations of their powers. That's fairly straightforward. If the constitution of the company states that contracts in excess of 5 million, for example, have to be approved by shareholders, that is a limitation on the powers of directors. They cannot then enter into a contract for 10 million. That would be exceeding the limitation powers. Such contracts can also be set aside. Avoiding a conflict of interest, unfettered discretion, exercise their powers for the purpose for which they were conferred. Any questions about this? No questions. The fiduciary duty of a director. In most instances, or many instances, will terminate the director resigns or leaves office if they are no longer a director. If, however, where the breach involves competitive activities, then, like for the opportunity rule, etc., the fiduciary duty will not come to an end when the directorship ends. What this means is that a director, if an opportunity presents is to a director, they learn of an opportunity, they are a director, and they realize, but this can be very lucrative to themselves. Merely resigning from their position of director will not terminate that duty. They resign and then take up an opportunity that came their way because they were a director. They cannot evade their duty to avoid a conflict of interest by resigning. The duty continues after resignation. I'm asked, but for how long does it continue? 6 months, a year, 2 years? There's no time attached to this. But if it can be proven that they have been following opportunity which came to them while they, or as a result of them having been a director, if a direct is obvious or can be proven, they can still be held liable to pay those profits they made to the company. Okay, questions? Fiduciary duty. What we did in partnerships, just maybe a little bit more elaborate, but nothing new. The duty of care, skill, and diligence. Also, that part. So this is also not also new. We learned when we were doing this, that partners in a partnership must act with good, reasonable terms we used at the time. They must act with reasonable care. Similar duty, act with skill and diligence. This is a delictual duty. If they are negligent, they commit a delict. The company can claim their losses they suffered as a result of their negligence. Not a particularly strict duty. This in partnerships as well. Utmost good as opposed to reasonable care. We've also saw on Tuesday that there are no specific requirements for somebody to serve as a company director. You don't have to be a lawyer or an accountant or have fancy academic qualifications. When the court judges whether reasonable care has been exercised or not, the court will look at the questions: did the director act in a way that a reasonable person, ordinary, reasonable, common or God type person would have acted? They also look at the individual director and the knowledge and experience of that particular director. What would a reasonable person with the same knowledge and experience have done? So, for example, somebody who is a first-year accounting student will be measured against what would a reasonable, sensible first-year accounting student have done. Myself, however, somebody that's a law lecturer for 23 years, will be measured against the standard of a reasonable person, 23 years experience in teaching law. So obviously that means I will be held at a little bit of a higher standard than a first-year student. It will also depend on the nature of the company's business, and if a particular duty was assigned to a director. So if somebody was appointed to the board with a legal qualification, with a specific assignment that they should keep an eye on the legal affairs of the company, then that to be taken into consideration. But if you go into the court, you will find many court dealing with directors breaching fiduciary duty, but not so many regarding breaching their duty of care and skill, because the standard is not that high. They can be held liable for damages. Breach of fiduciary duty for damages, as well as for profits made. Due to act with care and skill, liable only for damages. Okay, so those are the two main duties that directors have that arise from common law: the duty of good faith and the duty of care and skill. Word of warning that I gave you when doing partnerships, I will be applying very strictly. These are separate duties. Do not bundle them up. If you write in a question about the fiduciary duty of care and skill, I will draw a line through your entire answer. There is no such a thing as fiduciary duty of care and skill. There's a fiduciary duty and there's a duty of care and skill. And then just very briefly, I don't normally assess this, but you might be interested in this. We all know now, and we're with the fact that must avoid the conflict of interest. Does it mean that under no circumstances whatsoever may the director enter into a contract with the company which board he serves? Is no, it's not an absolute no, as long as it is a board and that all facts have been made clear to the other directors. It's usually done by approval. The director into a contract with a company. It's normally presented to a general meeting for the general meeting to decide and to give. If the shareholders have decided that the contract at arm's length, it's above board, it can go ahead. If, however, this is all done hush-hush and under the foot, the company can decide to contract will be voidable, company can set it aside. Okay, this one, a slide I'm actually going to skip. I don't normally assess this. Relates to personal instances where directors can incur personal liability towards others. For example, when they misuse company business, or Companies Act provides that if a director carrying on the business of the company recklessly and fraudulently, directors be held personally liable for any money, any losses suffered by either the company or by a third party as a result of their reckless and fraudulent acts. Okay, that's it. Thank you very much. Any questions?
No questions from me.
Okay. It's not that late. You can also spend some evening with your family and relaxing a little bit. Not a particularly complicated unit. Clear revision of what we did semester in internships. Do sometimes, quite often, ask questions about this in the assessments, but it's an important unit. We went through it quickly, neglect. Saturday morning, 10 o'clock, then a quick revision class. Will not be longer than, say, max 3/4 of an hour. For those of you that do have the time to attend, just to prepare you for Friday night's test. Thank you so much for joining. Have a lovely evening further. Bye.
Thank you, ma'am. Bye-bye.